consider a settlement agreement in Smith versus Jones. That's even so there's a continuum of what is more and more specific. And OPMA also says that whenever there's an ambiguity in the language of OPMA, the courts are required to construe that language in the way that most gives effect to the legislative purpose of OPMA, which is to give the public as much information as they need so they can adequately participate in the democratic process. So, therefore, since it's ambiguous, you have to interpret it in a way that is most conducive to the public knowing what's going on. And the judge agreed. He said, and he quoted a case, cited a case, I think it was a Monmouth County case. No, I believe it was a Mercer County case of the State College case. That whenever you describe what's going into executive session, what you're going to talk about, you have to describe it with specific, as much specificity as you possibly can, without undermining the actual reason why we're going into executive session. Now, what I did was, I decided to take this on the road, and I went and I opened every municipality in Atlantic County. I picked Atlantic, it started today, I think we'll start right here. I opened them for their executive session meeting minutes, the three most recent the minutes of the three most recent executive sessions for which you believe that minutes are available to the public in whole or in part. And for each resolution, for each set of minutes responsive to number 1 above, the resolutions that authorized the executive session in accordance with NJS 810:4-13, just to see what they come back with. So I got a whole bunch of responses. I found 17 of the towns were in non-compliance, either or both. So I sued all 17 of them for the same $200. I got a lot of bang for my buck. And I served them all. I got a friend of mine, we went down, we traveled, I had a little map. We traveled all the way around. We went in and served all the municipal clerks. It was a great day. And we brought them, so we drugged them all into court. And they were not happy. They eventually, most of them, 16 out of the 17, said, I told them, I want to settle, let's do the right thing. Even if you don't think I'm right on the law. I mean, all I'm asking for is just for you guys to be as open as possible with your citizens that are paying taxes to you guys. You know, you should want to do this. And some of them sincerely wanted it. Some of them acted sincere, but they really didn't want it. But 16 of the 17, they all settled. There's one town that just wouldn't settle. And that was Port Republic. We had to go to court and they lost. So I won one and settled with 16. But the settlement agreements, I wrote up this memorandum of understanding that went into excruciating detail on how they're going to make these resolutions. And it said that you have to do as much as possible. You have to say as much. So even if, I said that even if there was a settlement offer, if let's say you had a slip and fall in front of your municipal road, and the guy sues you because he says you didn't pick up the leaves or whatever you're supposed to do, and his attorney submits a settlement offer to you saying, I want to settle the case for $20,000, you should tell the public that we're going to go into executive session to discuss. We received a settlement offer from this guy for $20,000. We're going to discuss it in executive session. Now, of course, you can't hear what you're going to talk about in executive session, but remember, the reason why the litigation exception applies is to protect the town, is to protect the town against the adversary. It's so they can get and say how we're going to deal with this. The adversary already knows that he offered you $20,000. So you don't have to hide that from the public. Why do you want to keep the public in the dark as to what the settlement agreement is? The only thing that you have a legitimate need to keep from the public is the stuff that you can't let the adversary know, whether it's a contract negotiation or whether it's a litigation issue. And on personnel issues, just because personnel is different, when they discuss personnel issues in executive session, they're supposed to release the minutes of the executive session so that the members of the public can read them and figure out what it is that they talked about and essentially what they did to who and why. They're not allowed, so when they go into executive session to talk about personnel, it's not because they're trying to keep something from the personnel. It's because they want to be able to discuss private things about personnel in a way in which they're not impeded from having frank, candid conversations because the members of the public are sitting right in there like staring at them. So, but that just doesn't mean that just because the thing is allowed to be discussed in the executive session, that the minutes of the executive session shouldn't describe essentially what happened. And they should be, unless there's some overriding privacy interest of the member of the public. Now, for instance, let's say that a person asks for a leave of absence because they have a dread disease. And that's discussed. Now, you're not, the person's privacy interest in their own medical problems, that supersedes the public's right to know what those medical problems are. That makes sense. Well, let's say that what they're talking about is we're going to discipline the police chief because he fixed a ticket or something. Well, the public's interest in knowing that exceeds any personal privacy expectation that officer has. And so the higher up on the food chain these people that are being talked about, the officials and the employees are being talked about, the less of a privacy interest, at least this is the way I view it, is that they actually have. So you should be able to get the executive session meeting minutes with enough detail so you can see exactly what's being discussed. So if it's true that if you obey the law, town, and I can find out 30 days from now under Judge Lawson's rule what it was that you discussed, why can't you tell me right in the resolution before the executive session even happens what it is? If it's just a matter of 30 days, I want to know anyway. Why not just tell me up front? We're going to discuss the ticket fixing by the allegations of ticket fixing by the chief of police or whatever it is that you're discussing. So basically, my feeling is that they should, and I get them to agree to this, is that the 16 towns in Atlantic County are operating under this, under a court order, that the municipal attorney at the meeting is supposed to kind of predict, based upon the person involved in the nature of the personnel discussion, whether or not the details, to the extent the details will be available in 30 days when the minutes are released, and then put that same information, to the extent that it's reasonably calculable, in the resolution that calls or authorizes the meeting to initially. So that is the rule that I think it ought to be. Now that's just my view. I'm not sure if any superior court judge will actually enforce that, but I think that's the way it should be. Is the meeting minutes, is the answer about the resolution has to specifically tell you what they're talking about in as much detail, be it personnel, be it lawsuits, be it contract negotiation, without undermining the need for, or putting the municipality in jeopardy or individual privacy rights putting that in peril.
When they went into it, I'm sorry. Thank you. If they, in that resolution, are they permitted to have a catch-all and any other issues that arise? And,
no.
Okay. And if they have some items specifically enumerated and then something else comes back that was not enumerated, are they supposed to come back and say, we're talking about this now?
Yes. We're going to go in to talk about litigation. See, here's what I think everybody ought to do when they're tapped, to really drill into this. You send them the open request, they said, I'll repeat it. The minutes of the three most recent executive sessions that you had, for which you assert the minutes are publicly available in public part. 2, the resolutions that under NJSA 10:4-13 authorize those meetings. Now, that's going to take a bunch of stuff. What is, first off, you're going to see is how recent those meeting minutes are that come in. Okay, so you're going to have a town, like I had a town, I forget which one, it was Atlantic County. I made this request in August of 2009, asking them for the 3 most recent executive session minutes for which they could be disclosed. And they gave me some stuff from March of 2008. Meaning that, we've had executive sessions every meeting here, from March 2008 to August of 2009, but none of those things were even redacted versions of those aren't available. Well, there's a problem there. Okay, so how up to date are you guys in getting these minutes out to the public? And then now they're giving you minutes of, doesn't matter when they are, and they're giving you the resolutions that authorize the executive sessions at which those meetings are recorded. Now you get to look at the executive session resolution and compare what they said they were going to talk about to the actual things that they did talk about at the executive session. And there should be a one-to-one correspondence between the things that they're talking about, the things they say they're going to talk about, and the things they actually did talk about. If you find that they were going to talk about 1, 2, and 3, and they really talk about 1, 2, 3, and 4, you're right, they violated. They're supposed to go, if they said we're going to talk about this litigation and this litigation, and they talk about 3 things, what they should have done is when that third thing came up, somebody should have said, oh, wait a minute, we can't talk about that because we didn't tell the public we're going to talk about that. Adjourn the executive session, go into public session, pass another resolution saying you're going to go in and talk about number 3, and then go back in and talk about number 3. Now that might sound like a lot of work, But that's what, there's a quote in one of the court cases that say the government has a responsibility to turn sharp corners with its citizens. You can't play fast and loose with this stuff. This is important. But what you're going to find in most towns is it's not even going to be like, well, you're going to be able to, you're not going to tell a correspondence between what they talked about and what they said they were going to talk about, because what they said they were going to talk about is so vague. But you could then go to the town council and say, look, you said you were going to go in and discuss legal issues, personnel issues, and any other things that you feel like talking about in executive session. That's what your resolution says. But when I see that you went to executive session, you can talk about this piece of litigation, you can talk about this piece of litigation, and that piece of litigation, and that personnel issue. Now, each one of those pieces of litigation were filed in the Superior Court of New Jersey. Any citizen could go down there and just pull that file and look at the litigation. So why couldn't you have told us in the resolution that these were the things that you're going to be talking about? And those are good questions. They're going to have a hard time answering that question if they care. But that should be brought to their attention if they're doing that. And say something else. I have a lot of people call me from a lot of towns all over the state complaining about their. First off, everybody's town is the most corrupt in New Jersey. They call me. Everybody, Amesport, whatever. They're all bad. Oh, Asbury Park, that's even worse. I mean, I don't know. They're all bad. That's what when they're calling me. Usually, what happens is these are people that have been asleep. They haven't gone to any of these meetings, they haven't done anything, they have participated, zero participation in their local government. And then all of a sudden there's an issue. They're going to build a swimming pool. They're going to tear down a swimming pool. They're going to cut down an oak tree. They're going to do something. Now they've recognized that people start showing up at the meetings. They're doing something really bad, whatever it is. Now, they've been doing bad things that they discovered pretty quickly for the last 5 years. And they've been leading up to this thing, and now we're catching on. Then they say, well, let me see those minutes that existed 5 years ago so we can now start to track how you did this and who knew what and when they knew it. And they're trying to do this forensic investigation of this corruption and conspiracy in the municipal government. But then they find out, then for the first time they find out, there is no minutes. They don't have them. The clerk had them, he took them home with him, and they lost them. His computer crashed, the dog ate them. Something happened to the minutes. Or the minutes were so vague that they're useless. And now the record that they need to make their case is never going to be recoverable. So my thing is that even if you have no issue with your town, even if you think your town is the mayor and the council are doing the best job, don't let them get away with these shoddy minutes and resolutions that don't tell you what they're going to talk about. Hold their feet to the fire. Hold them accountable. Make sure they're obeying the law, because it could be that 5 years from now there will be an issue. And you're going to want to know what they were talking about then. And you're not going to have it, and you're going to be sitting there with empty hands, not being able to make your case. And then they're all going to say, yeah, you're right, that prior administration, they really should have done a better job on those minutes. But man, we're really sorry, but they just don't exist. No, don't let them get away with it. Go to your town, and before is like preventative maintenance on your car. You got to go to your town, you got to fix the stuff before it breaks. And this is one case where I've seen this happen. My experience is time and time again. It's like proper municipal hygiene. You have to make sure it's being done all the time. So I would say seriously, guys, make that request. And if you find that there's problems with it, correct them now.
What are the clerks told they have to do as far as the minutes? It sounds like it's whoever's interpretation that they just go with.
A lot of it is they defer to the municipal attorney. A lot of it is nobody even talks about it. And that's something that is just like astonishing to me, is that like I'll find a blatant violation, like something like the town council doesn't keep minutes of its executive sessions, or something ridiculous, maybe not that bad. And I'm like saying, you guys have an administrator getting paid $120,000. You got an attorney getting paid $140,000 a year. You got all these people with plaques on their walls and certificates of law degrees and everybody else all floating around. They're all at these meetings. They've been at these meetings for the last 5 years, and it never occurs to any of these people that they're supposed to like have minutes of these executive sessions. It takes some guy from Somerset to bring this to your attention. I mean, I'm not getting paid anything for this. What are you people doing for your money? I mean, there's nothing wrong. So usually what happens is a lot of times the clerks are generally well-meaning people. I've run into very few evil clerks. Most of these people are afraid for their jobs. It's not, when they're not giving you information, more times than not, it's a reflection of the people behind the clerk. It's the administration, it's the town council, it's the mayor, it's somebody saying, no, we expect you, regardless of what they teach in clerk school, we expect you, if you want to be here, you put a lid on it.
John,
And that's, yeah.
Sorry to interrupt, but why don't we just take a few more last questions?
Okay.
Call them right here.
We'll just get rolling.
Yeah, we'll go down to a bar and continue.
There's several in parentheses. And yeah.
What's up, Don?
Heard about Nixon erasing the tape. In Neptune, you cannot understand what the tapes say. They are incomprehensible. Plus, you don't know who's talking. I don't know what to do about this. You cannot understand. I've asked for tapes. You cannot understand. You can understand the mayor sometimes. Their loud voice. But you cannot hear anything else. Now, I'm deaf, but I've had other people listening who cannot understand. What do you do about this? Like, totally
You can bring you can bring your own equipment, but there's nothing in Oprah or the Open Public Meetings Act or any other law that says you have to, if you make a sound recording, it has to be audible. Just like if a record is destroyed, there's no relief under the Open Public Records Act for that. If a record is missing, there's no relief. If a record is deleted or discarded, again, it's Oprah doesn't set forth this huge paradigm by which they have to deal with records. It's just if the record exists, you can have it. If it doesn't exist, it doesn't say what the quality of the record has to be. It doesn't say what the record has to say. So no.
Common sense should be.
There's no rule that says they have to audio tape their meetings at all. They only have to keep reasonably comprehensible minutes of their meetings. So to the extent that there's no rule that says they have to do it at all, you can't request that they're going to do it in a certain way.
In Neptune, they supposedly audio tape the meeting, and the minutes are made up from the audio tape. So,
Yes.
It's not reasonably comprehensible.
Yes.
I have a hearing problem. I have 2 hearing aids. And I went to our meetings and I could never hear anything.
I think they
So I went and I got all the records for the ADA. The Martin Disability. And I took them from Washington and I took them to our township and I gave them to them. And our administrator, who was an ex-cop, and said he had too much cop left in him, I agree. He told me he didn't agree with what I was saying. I said, well, I'm reading this from the papers from Washington. To find another person who's hard of hearing, got the papers right from New Jersey, and took them in there, and they had to put these speakers up, because I have to be able to participate in the meeting.
Yes.
And I don't think it's fair that, even though now I can hear fine, nobody else can hear either. So when I could hear, the whole group.
Well, that's interesting. I mean, because basically they don't have to keep an audio tape, but they do have to have it where you can listen. The whole purpose of it is to observe and to listen to what's going on at the meetings. So let's say they had it where you can't hear the ADA. I think that's a pretty good argument. So there, if you have the speakers and you can actually, then a person can actually record the meeting themselves. That we have a right to do, video or audio taping. So I think that's a good way to go, is to get a person that's hard of hearing and have them bring an action under the ADA. Sorry?
The Americans with Disabilities.
I don't know.
To piggyback on top of that, my wife used to work for a municipality in Neptune, and she worked for the Board of Health. And under ADA, she was the coordinator. And there is a law, and they, like you said, public participation, especially in the meeting. She bought the sound system that they said that they had a very bad one, and put the loop, which she's saying with the hearing aid, they'll even furnish the headphones and everything else. It's the law. It's a federal law under ADA, and they have to provide it. And also, like interpreters in a courtroom for the deaf. My son is deaf too, because he had an accident one time, and they weren't prepared. And we had to get interpreters to come in for the prosecutor as well as the defense attorney. But what I'm just trying to say, where these problems exist, because the microphones, like what you gentlemen were talking, if you don't have the microphone in front of you, it's hard for the person in the back to hear you or in the middle, okay? It's drowned out. But that's something that they have to push for, ADA, to make sure they recognize it in the meetings, because they use that at every meeting I went to.
That would be what we would need as a person with a disability to go to, and it doesn't have to be your own town, it could be any town.
The ADA, they have to have a representative on their staff, each town, because they get federal funding, and it mandates that.
Oh, that's a good, I'll tell you, it sounds like a whole fertile field for litigation is what it sounds like
They're
there.
a real smart person.
They use this as part of the cover-up, and there is often at a meeting a huge distance between the dais and the people. And one time, I took my chair and I put it up under the dais. I said, "I can't hear you." This is a political statement. But this is very interesting.
Talking about federal, is there any hope for getting something similar to the Open Public Meetings, Open Public Records Act on a federal level?
What do you mean?
Well, I've been trying.
There are federal analogs to the Open Public Meetings Act and the Open Public Records Act, but they apply to the federal government.
That's what I'm looking for.
Yeah, state, I think it's going to be state law is going to control state government. I don't think you're going to find, unless they find it, yeah.
From a federal agency. I'm trying to
Well,
get
it's federal,
records from a federal agency.
make your request under the
Oh, I see,
Freedom of
okay.
Information Act.
Yeah, I did, yeah. No,
No.
that's not my point. But, no, what I'm getting is answers from an agency that just says, we have the right to withhold these documents. We don't have to give you any information about why.
Well, they may or may not have that right under the Freedom of Information Act. Just like Oprah, Freedom of Information Act creates this whole framework under which they're supposed to respond, and there's exceptions.
Who do you appeal that to? Because they
Federal
appeal
court.
it through their own, so I'd have to take the federal court.
I mean, I'm sure you have to exhaust your administrative remedies first.
Yeah, I did.
Yeah, then you go to federal court.
And is that, do they cover your fees or not?
I don't know the answer. I've never.
That's the next question. This has anything to do with exactly that stuff, but what type of things can you talk about when you have comments from the public?
Well, when you go to a public meeting, you have a First Amendment right to talk about whatever you want. In addition, under the Open Public Meetings Act, if it's a municipal meeting or a Board of Education meeting, they have to set aside time for the public to comment. Not at a county freeholder meeting or a zoning board meeting or any other kind of meeting. So they may not have the obligation to allow you to comment. Now, of course, there's exceptions because for a zoning board they may have a hearing at which the public has a right. So just because there isn't a right under the Open Public Meetings Act for you to speak, that doesn't mean that some other statute gives you the right to speak. But in terms of what you can say, as long as you're not disrupting the meeting or defaming someone, you can say whatever you want.
Okay, yeah, like our meeting last night, we had a lady whose husband was really beat up in the election. So she got up there and told them during public comment that they owed her husband an apology because there was nothing, unless they could absolutely prove, which they couldn't, that he said these things or did these things, she felt like they owed him an apology. And the mayor immediately said, whoa, no talk, no politics, no, we can't talk.
Now, what I do in circumstances like that, and it's a specific situation, but when I have someone who goes to a meeting and is otherwise following all the rules and wants to talk about something, and they get cut off or shut down, what I do is I bring a lawsuit in Superior Court Special Civil, okay? And I bring it in Special Civil, has a jurisdictional limit of $15,000 in damages. but your First Amendment rights are enforceable there. And why do I bring it in special civil? And I've done this successfully. I bring it in special civil because you bring it in Superior Court, there's a $200 filing fee, and discovery is going to last, because it's a civil rights case, discovery is going to last 450 days. So you're locked into at least a year of litigation, at least. If you go to special civil, it costs $30 filing fee, $30 to get it served. You get a court date in 30 days in most counties. You're not going to have a trial that day, but then you'll have a trial in another 30 days. And so what I do is I say, okay, how much is that person's rights worth? Is it worth $15,000? Maximum $15,000. Is it worth 10? Is it worth 5? And what happens is you get the other town's attorney, you get their JIF involved. I did this once where I had 2 attorneys. So you have one guy, you have Fred making $300 an hour, and then like Sam with $200 an hour, and I dragged them to court twice on a case where their maximum exposure is $15,000. I must have cost them like at least $5,000 to $10,000 in legal fees, because Mr. Mayor told Mrs. Whatever to shut the hell up. He's not allowed to do that.
Well, it's kind of sad, because they tell you something, and you as a layman, you don't know, and you believe what they tell you, and then when you find out later, they've been lying.
That's why you have to challenge them. That's why it's not for everybody. A lot of people are timid. A lot of people don't want to call attention to themselves. But you have to go out there and push the envelope. That's why if you're willing to do it, it's important to do that. It's important to hold their feet to the fire and say, look, you can't push me around. I can talk about whatever I want. You sue them, you win, and that emboldens the meeker people, the more mild people. They'll say, well, I'm not going to allow myself to be pushed around because there's been a precedent set. I know what line I can go up to now, and they're not intimidated by this blustering of the mayor. And I don't take any pleasure in seeing the taxpayers have to pay, because the mayor is not going to cost them a nickel out of his pocket. It's going to be the insurance company, it's going to be the taxpayers going to end up paying this. But I don't know any other way to do it when your rights are being.
Tools that you have.
That's all that you have. So hopefully, what you can do is by having one case and it will be in the newspaper, the Burlington County Times, that the mayor is told he's wrong. You can't do this anymore. What that will do is that'll provide a guidepost and a bright line for everybody in that whole area.
I was the next person to talk, and he told me again that I was not to talk about politics, and I told him, I'm in the United States of America, and I have the right to freedom of speech, and I'm going to say what I have to.
And it says,
you can either sit there
right,
and listen, but I'm going to still keep saying
it says right in the Oklahoma that you have the right to speak of anything that you believe is going to be of interest to the members of the municipality. So once you open that up like that, you can't have some content-based where the only okay comments are the ones where you praise the mayor about what a great job he's doing, but as soon as you criticize him, you can't say that because you're being negative. I mean, that's the whole idea. This is a rough and tumble debate. This is when it's working. Democracy is a messy thing. It sometimes hurts people's feelings, but that's how it's supposed to work. And the mayor has no right to do what he did.
Can they limit you on how long you can?
Oh yeah, they can set up reasonable time. They can say everybody gets 2 minutes, everybody gets 5 minutes, everybody gets whatever it is.
Stop you from speaking again.
They can set up reasonable time and manner restrictions. They can determine the length of the portion, and I think it would be fair to say that they can say one person can speak once. I think they can do that.
Can they arbitrarily just close the public session?
Not if there's people who haven't spoken yet. I mean, I know there's some jurisdictions that say 3 minutes per person, maximum 30 minutes. So the question is that reasonable or not?
But they haven't set a parameter.
Well, I mean, if no parameter has been set, then there's no rule to enforce. They can't just make it up on the fly. I mean, if I were advising a town, I would say, look, create your regulations. Have your regulation, pass a resolution, pass an ordinance, whatever. And the ordinance would say maximum of 3 minutes or 5 minutes per person, and 1 person per whatever. So they have to have an open comment period. So 1 person per, each person gets to speak once. That's reasonable. Now, if ordinances are coming up for vote, then those have their own specific times. Same thing, 3 minutes or 5 minutes, whatever is reasonable, and you only get to speak once. Yes, ma'am.
Can you give your thoughts on this recent news article I read in the Asbury Park Press, so it took place in Monmouth County, where I'm going to say that the mayor said even though they videotape their meetings, during public comment, they're going to cease videotaping.
I mean, that's fine. I mean, there's no obligation to videotape. I mean, I've always felt that public agencies cause themselves many more problems by recording stuff than by not recording it. I mean, if I were advising public agency, I would tell them, don't record anything. You know, why? You're just creating problems for yourself. Because if you misbehave, you're creating a record of your own misbehavior. And so, I mean, again, from the perspective of a public agency. Now, you guys have the right to record meetings. So just because a public agency doesn't do it, doesn't mean you're, if it's important enough, just like there's at least 2 video cameras in this room tonight. So just like if it's important enough for you to videotape it, then videotape it, record it. You're allowed. The Supreme Court has said you're allowed to record it. So from my perspective, as a from a public agency's perspective of risk management, I would say don't. I would say don't, because more often than not, you're going to be accused. People are going to be accusing you of stuff, and then you want to create that record or not.
I just think it sets up a real chilling effect on public comment if their protocol has been to videotape the entire meeting, including public comment, and then they're stopping to shut things down during public comment.
Well, how is that chilling?
I think for other people in the community, a lot of times people come up and speak at a meeting, not just because, and these are, I'm talking about things that are broadcast too and are available. I mean, that's why they're videotaping, they're putting them on public access, they're putting them on the internet. A lot of times, I know for myself personally, I can make a phone call to the administration and get the information I need, but that only benefits me. I don't have this mass media, so I get up there a lot of times and speak because I want the people in the audience behind me to hear it, and I want to see the viewing audience, those who take the time. So I see that as decreasing the transparency and decreasing the openness, because it doesn't broadcast that part of it as well.
Right. I mean, it makes me suspicious. I mean, why are they afraid of broadcasting public comment?
First of all, where did the little folders go that we were supposed to take?
I owe you one. You'll have to. I gave them all out. I'm sorry.
How come you did that? They were up there for everybody.
Okay.
Thank you.
Well,
second question: Do they have to have a public comment period? I've been telling them.
Yeah.
They
Yes.
do. The
Now, town councils,
School board.
they do. They have to have them.
and school boards have to have it. Okay.
Yes.
In our town, they actually use the police one evening to stop the discussion. And it was one more word out of you, and you will be removed. And it was during a compliment actually was making comments, and I was responding to it. It was during the public comment, and they actually called the police in. And they said, one more word, and you will be removed from the meeting.
I think that's an abuse of their authority, and I think they got to be hauled into court, is what I think. It depends on the statute of limitations, how